are on the application of AB versus Uxbridge Youth Court, concerned an application by AB for a cost order against the Director of Public Prosecutions, DPP, following AB's withdrawal of a claim for judicial review. AB, recognized as a victim of human trafficking, had been charged with criminal offences allegedly committed when he was 14 years old. The Crown Prosecution Service decided to prosecute AB, and this decision was upheld by the DPP. AB applied to the Uxbridge Youth Court for a stay of proceedings. This was refused, and AB brought a claim for judicial review. The parties subsequently agreed that the DPP would reconsider the prosecution decision if AB withdrew his claim. The key issues to be decided were what costs regime applied, the civil or criminal regime, and, if the criminal regime applied, could and should the court make a costs order against the DPP under Section 19(1) of the Prosecution of Offences Act 1985. AB argued that the civil costs regime should apply because decisions on whether to prosecute are similar to typical judicial review decisions, so the usual principle that costs follow the event should apply. It was argued that when a prosecutor makes an unlawful decision that it is in the public interest to prosecute, he is not acting in the public interest, and the rationale for reducing the prosecutor's exposure to costs falls away. If the criminal regime was found to apply, AB argued that the DPP's error in applying the wrong test amounted to an improper act or omission under Section 19(1), which allowed a costs order to be made in those circumstances. The DPP argued that the criminal costs regime presumptively applied to criminal proceedings, including for any appeals or judicial reviews arising out of such criminal proceedings, and that, per Murphy v. Media Protection Services Limited, save in exceptional cases, prosecutions and appeals in criminal cases should be and will be subject to the criminal costs regime. The case, it was said, did not involve exceptional circumstances warranting displacement of this principle. The court held the criminal costs regime applied per Murphy. It rejected the Section 19 argument, finding the error did not meet the high "no reasonable prosecutor" threshold to qualify as an improper act. Accordingly, permission was given to withdraw the judicial review claim, but no order was made as to costs. For a detailed summary of this decision, visit tmclegal.co.uk.